So the story really starts with Lamar Smith, chair of the House Science Committee and also climate denier in chief.
Better to get your news directly from the president. In fact, it might be the only way to get the unvarnished truth.
Back in 2015, when some scientists at NOAA, the government agency, had put out a study studying ocean temperature records, and their study concluded that ocean temperatures were rising slightly faster than previous studies had indicated. Lamar Smith decided that this study in and of itself was evidence of, at that time, Obama administration political interference. He did not think the study could possibly be correct, and he asked for a whole trove of documents from the scientists, basically in an effort to intimidate them, in an effort to look for something that supported his thesis that the ocean couldn't possibly be warming. And you can imagine that the documents in this case related to this study, they'd just be a treasure trove for someone like Lamar Smith, because it was a situation where scientists truly were looking at data and deciding that actually the ocean had been warming faster than previous studies had indicated. So there's something, there's, I'm sure, phrases in there and terms, things that would be very easy for someone like Lamar Smith to take out of context and suggest that the scientists had been, manipulating the data. So Lamar Smith, for the past few years now, has been trying to get these documents from NOAA. He was very aggressive during the Obama administration. Since the Trump election, he's more or less, given up on this. He doesn't need the documents as much anymore. He is no longer interested in trying to thwart the Paris Agreement, because that has happened. But there's been a court case going on since late 2015 where a group has been trying to use open records laws to obtain the same documents that Lamar Smith was unable to get. It's a situation where they're trying to get peer-reviewed correspondence, and they're trying to get internal communications, casually written emails, anything they can use to take out of context to suggest that these scientists maybe were purposefully adjusting the numbers upwards. And again, this is a situation in which they truly were adjusting an existing data set. And even though the study has since been replicated by other researchers, for someone who wants to make the argument that the scientists had a pre-existing agenda, I'm sure they could find an email in there out of the 9,000 emails at stake that suggests something along those lines, something they can take out of context like that. So NOAA has been fighting the case, and actually they've continued to defend the scientists even under the Trump administration. I think there's two reasons for that. I think one, the Trump administration has not really been staffing NOAA or any of the other scientific agencies. And two, I think even the Trump administration understands the importance in protecting confidential communications. They're not super eager to hand over things under open records laws. They may not be pro-climate scientists exactly, but by and large, they understand the importance of allowing government officials to talk to each other candidly for perhaps different reasons. But nonetheless, they want to make sure that these existing protections are applied. So 2 weeks ago, the federal district court ruled in favor of protecting the scientists at NOAA, agreed that their confidential communications should remain confidential, that there's a real government and public interest benefit in letting scientists communicate candidly with each other, and to let their peer-reviewed correspondence remain protected. And we're very pleased about that. We filed a brief in support of NOAA back in January. We were joined by the American Meteorological Society and the Union of Concerned Scientists. And so it's really terrific news to see the federal judge agree with us and agree with NOAA that there's real public value in letting scientists communicate with each other candidly and confidentially, as has historically been the case. What the conservative group seeking the emails in this situation, and Lamar Smith was trying to do, was really violate traditional forms of confidentiality among scientists. We've definitely been talking to quite a few scientists who are employed by the federal government. This particular issue with open records laws, again, I don't think the Trump administration is super eager to hand over scientists confidential documents under open records laws, because they're not eager to hand over any documents under open records laws. So in this particular area, we've not seen an increase in issues. We have seen some problems where scientists have been suggested by their superiors that they should stop researching certain areas, or they should stop communicating about their research. They should rewrite their grant proposals to not include the words climate change. I mean, you've seen these sorts of stories in the news. Unfortunately, this is something that's happening. A lot of states now have realized that their laws can be easily abused and misused. So something like, I think it's 41 states now have some sort of protections for scientific research, because they recognize that these laws were written to apply to agency policymakers, And scientific research really is a different bucket, and you can achieve scientific transparency in the ways that has traditionally happened, like publishing peer-reviewed studies, having people evaluate and replicate the research. And you don't need scientists' emails to sift through everything. Really, what scientists' emails do is they create a red herring that forces scientists to defend every casually written note they've ever, written to a colleague after midnight, thinking about something, engaging in devil's advocate debate, some sort of like thinking out loud and tossing around ideas that weren't really meant to be for public dissemination because they were just trying to, think through things. Every candid, confidential communication being made public, which is what emails sort of are, that's a really dangerous proposition for scientists and for the public that relies on the science. I mean, we don't want scientists to feel hamstrung in their communications with each other. We'll see what happens if the conservative group Judicial Watch does appeal, but I do actually feel pretty optimistic about it because in this one instance, the interest of federal climate scientists and the interest of the Trump administration are actually aligned, which is really nice news for a change.